Thank you for visiting my channel. Before we start, please hit the subscribe button so you'll be notified of future presentations. Our topic for today is legal and conventional redemption in the law on sales. Article 1600. Sales are extinguished by the same causes as all other obligations, by those stated in the preceding articles of this title, and by conventional and legal redemption. So there are three classes of causes that extinguish an obligation, including a contract of sale. The first one is the common causes, which are enumerated under Article 1231. The special causes, which we will no longer discuss because we have discussed them during our regular classes, and the extra special causes, which are the conventional redemption and the legal redemption. The conventional redemption is discussed under Article 1601 to 1618 and the legal redemption under Article 1619 to 1623. Conventional redemption. Conventional redemption is provided for under Articles 1601 to 1618. Article 1601 provides, conventional redemption shall take place when the vendor reserves the right to repurchase the thing sold, with the obligation to comply with the provisions of Article 1616 and other stipulations which may have been agreed upon. Conventional redemptions is what is called sale with right to repurchase or pacto de retro sale. Who are the parties to a pacto de retro sale? The parties are the seller a retro and the buyer a retro. What is conventional redemption? Conventional redemption is one where the seller reserved the right to repurchase the thing sold, coupled with the obligation to return the price of the sale, expenses of contract and other legitimate payments, and the necessary and useful expenses made on the thing sold. Right to repurchase must be reserved at the time of the perfection of the sale. Article 1616 says, the vendor cannot avail himself of the right of repurchase without returning to the vendee the price of the sale and in addition, number 1, the expenses of the contract and any other legitimate payments made by reason of the sale, and 2, the necessary and useful expenses made on the thing sold. So, halimbawa, si Juan gustong magtayo ng negosyo, so kailangan niya ng malaking halagang pera. So, naisipan niya na ibenta ang kanyang bahay at lupa kay Pedro. Pero mayroon silang usapan na after 5 years, ay bibilhin niya muli ang kanyang bahay at lupa kay Pedro. So, ito yung tinatawag na sale with right to repurchase. Si Juan ngayon, siya ang seller a retro, si Pedro's buyer a retro, at ang kanilang transaksyon ay pacto de retro. Okay? So, yung stipulation na yon that he will buy back the property within 5 years must be stated in the contract of sale itself. Dapat nandun mismo yan sa contract of sale nila. Hindi pwede na nasa ibang dokumento, hindi pwedeng salita lang, dapat nakalagay yun sa contract of sale to be enforceable. Okay? So, halimbawa, nagkabilihan sila year 2000, ang usapan nila, he will buy back after 5 years. So, 2005, dapat he must be willing, ready, and able to buy back the property, to exercise his right of redemption. Otherwise, he will lose the right of redemption. Okay, so pagdating ng 2005, asensado na si Juan, nagnegosyo nga siya. So, magkano ang ibabayad niya kay Pedro? Ito yon nasa 1616. Number 1, the purchase price itself. Sa ang example natin, 1 million ang bilihan nila noong year 2000. So, 1 million dapat ibalik niya. Pero hindi lang yun ang dapat niya ibalik. Number 1 sa 1616 is the expenses of the contract and any other legitimate payments made by reason of the sale. So, for example, they engage the services of a lawyer to draft the contract, for notarization, etc. Pagdating sa registry of deeds, maraming binayaran para malipat ang titulo sa pangalan ni Pedro. All these expenses must be included in the price that he will have to pay to Pedro. Pero hindi lang yun. Number 2, the necessary and useful expenses made on the thing sold. Remember that Pedro occupied or held the property for 5 years. So during that period, he may have caused some necessary and useful expenses. For example, nung binili niya yung bahay at lupa ay walang bakod, nagpabakod si Pedro. That's a useful expense. And then, pinapalitan niya yung bubong dahil sira na yung isang portion. That is a necessary expense. Pinaayos niya yung CR, yung kitchen, yung bintana. These are necessary expenses. So, yung gastusin na ito, dapat isasama ito sa ibabayan kay Pedro. So, may I recap under 1616? Ang ibabayad ni Juan kay Pedro when he exercises the right of redemption are the following: the purchase price, the expenses on the contract, and all legitimate payments, and necessary and useful expenses on the thing sold. Take note that luxurious expenses are not included in 1616. Subject matter of conventional redemption. Both real and personal property may be the subject matter of pacto de retro sales or sales with right to repurchase, although there are certain articles which are applicable only to immovables. Who may exercise right to repurchase? Number 1, the seller in whom the right is recognized by a contract. Number 2, any person to whom the right may have been transferred. And number 3, the person entitled by law. This is for legal redemption. The right to repurchase must be reserved by the vendor by stipulation to that effect in the contract of sale itself. It is a right reserved by the vendor in the same instrument of sale as one of the stipulations on the contract. Once the instrument of absolute sale is executed, the vendor can no longer reserve the right to repurchase. So take note that the right to repurchase must be stated in the contract of sale itself. It cannot be made in a separate instrument after the sale has been executed. Dapat doon mismo nakalagay yung reservation sa contract of sale. Kasi kung consummate na yung contract of sale, then hindi na pwede. Hindi na pwedeng belated ang reservation to repurchase. Buyer a retro has right to immediate possession of property sold. In pacto de retro sale, the buyer has a right to the immediate possession of the property sold unless otherwise agreed upon. The title and ownership of the property sold are immediately vested in the buyer a retro, subject only to the resolutory condition of repurchase by the seller a retro within the stipulated period. What is the period of redemption? Here are the rules. Number 1, if there is no stipulation or agreement as to the period is 4 years from date of contract. Number 2, when there is a stipulation or agreement, this stipulation or agreement should not be more than 10 years. Because if it is more than 10 years, it is valid only for the first 10 years. Number 3, when period to redeem has expired and there has been no previous suit on the nature of the contract, the seller still has 30 days from final judgment on the basis that the contract was a sale with pacto de retro. And finally, when period has expired and the seller allowed the period of redemption to expire, the seller is at fault for not having exercised his rights, so should not be granted a new period. How redemption effected? The seller a retro can avail himself of the right of repurchase by returning to the buyer the following: 1, the price of the sale; 2, the expenses of the contract and any other legitimate payments made by reason of the sale, and the necessary and useful expenses made on the thing sold. This is based on Article 1616. How redemption exercised? 1, valid tender of payment is sufficient. 2, express intention to repurchase by contract with redemption price. Take note that deposit of money with the clerk of court is unnecessary. However, if the buyer a retro cannot be located, the seller a retro can file consignation with the court of redemption price within the redemption period. When redemption not made. In the case of real property, the consolidation of ownership in the buyer by virtue of the failure of the seller to comply with his obligation to return the price and other legally mandated expenses shall not be recorded in the Registry of Property without a judicial order after the seller has been duly heard. Buyer is required to institute an action for consolidation where the seller a retro may be duly heard. If the buyer succeeds in proving that the transaction was indeed a pacto de retro, the vendor is still given a period of 30 days from the finality of the judgment within which to repurchase the property. Upon expiration of the 30-day period, ipso jure, the right to redeem is extinguished. This is based on Article 1606. No automatic consolidation of ownership in the buyer a retro upon expiration of redemption period. Legal redemption. Article 1619. Legal redemption is the right to be subrogated upon the same terms and conditions stipulated in the contract, in the place of one who acquires a thing by purchase or dation in payment, or by any other transaction whereby ownership is transmitted by onerous title. Take note that the right of redemption arises only when the alienation is by onerous title, like sale, dation in payment, or barter. What are the instances of legal redemption? 1. Sale of a co-owner of his share to a stranger. 2. When a credit or other incorporeal right in litigation is sold. 3. Sale of an heir of his hereditary rights to a stranger. 4. Sale of adjacent rural lands not exceeding 1 hectare. And 5. Sale of adjacent small urban lands, both merely for speculation. For purposes of the present discussion, we will focus on number 1, number 4, and number 5. Number 1 being sale of a co-owner of his share to a stranger. 4. Sale of adjacent rural lands not exceeding 1 hectare. And 5. Sale of adjacent small urban lands, both merely for speculation. Who may exercise legal redemption? 1. Co-heirs. 2. Co-owners. 3. Adjoining owners of rural lands. And 4. Adjoining owners of urban land. For redemption to be exercised, co-ownership must exist at the time the conveyance is made by a co-owner and the redemption is demanded by the co-owner or co-owners. Property subject of legal redemption. For co-owners or co-heirs, they can redeem real and personal property. But for owner of adjacent lot, they can redeem only real property or parcel of land. Question. This parcel of land is co-owned by A, B, C, and D. D alienated his interest to X. Would A, B, C have the right to redeem? Answer. Depends on the nature of the alienation. Remember that the right of redemption arises only when the alienation is by onerous title, meaning by sale, dation in payment, or barter. Otherwise, no right of redemption. So if D donated his interest to X, there would not be any right of redemption because the alienation is by gratuitous title. But if D sold his interest to X, then there will be a right of redemption because sale is by onerous title. Rural land requirements. 1. Onerous disposition. 2. Not more than 1 hectare. 3. The grantee or buyer must have another rural land. And 4. The parcel of land must be contiguous in order for the right to be invoked. For the right of redemption to apply to a rural land, there are several requirements. Number 1. The disposition made by the co-owners or co-heirs must be by onerous title. Ibig sabihin, either they sell it or they dispose of it by way of dation and payment. Number 2, the property that they dispose should not be more than 1 hectare. Kasi pag more than 1 hectare na, wala ng right of redemption. Number 3, the buyer should have another land. Halimbawa, si ABCD nagbenta kay X. Si X dapat may iba pang lupa para magkaroon ng right of redemption si ABCD. Kasi kung si X buyer ay walang ibang lupa kundi yung nabili sa kanila, walang right of redemption. Kasi pag yun ay na-redeem pa kay X, wala nang maiiwan kay X. So that is the third requirement. And number 4, the parcel of land must be contiguous in order for the right to invoke. Contiguous, ibig sabihin magkatabi. Yung binili ni X ay dapat katabi ng lupa ni X. Yun. So we will discuss this in the next slide. So here we have a little illustration. Here is a parcel of land co-owned by A, B, C, and D. 1/4 share each one of them. Ang adjacent lot owners are CX, CY, at saka si Z. Ito yung adjacent lot owners. So for example, D disposes of his property by way of sale to his best friend L. Binenta niya kay L ang kanyang 1/4 share sa 1 hectare na property na to. And then nagkasabay na gustong mag-redeem si X saka si A, sino ang may preference? Dito sa number 1, if co-owner and adjacent lot owner both want to exercise right to redeem, the co-owner shall be preferred. So pag nagkasabay ang co-owner saka adjacent lot owner, palaging panalo ang co-owner. Remember that. Dito sa number 2 situation, if 2 or more adjacent lot owners desire to exercise right to redeem, owner of adjoining lot with smaller areas shall be preferred. So halimbawa, sa example natin, D disposes of his property in favor of his friend L. L is a stranger to the co-ownership. And then X and Y would like to redeem. Sino ang may preference? Ang may preference ay kung sino yung mas maliit ang lupain. Halimbawa, si X ay mayroong 70 square meters at si Y mayroong 50 square meters. Si Y ang preferred. Si Y ang dapat may right of redemption because according to our rules, the adjoining lot owner with smaller area shall be preferred. Number 3 situation, if 2 or more adjacent lot owners desire to exercise right to redeem and both of them shall have the same lot area, one who first requested shall be granted. So halimbawa, nag-dispose si D ng kanyang share kay friend niyang si L, and then Y and Z would like to redeem at the same time, pero pareho ang ganyan. Sabi natin si Y mayroong 50 square meters, si Z mayroon din 50 square meters. So, sinong may preference? Kung sino yung nauna, unahan na lang. Okay, so let me recapitulate the rules. Pag ang gustong mag-redeem ay co-owner at adjacent lot owner, palaging panalo si co-owner. Pero kung ang nagkasabay na gusto mag-redeem ay parehong adjacent lot owners, for example, si X saka si Y, ang may preference ay yung kung sino yung mas maliit na lupain. Si X, halimbawa, 70 square meters, si Y, 50 square meters, si Y ang may karapatang mag-redeem. Pero kung gustong mag-redeem si Y sa si Z, pero pareho ang measurement ng kanilang lupain, pareho silang 50 square meters lang, then kung sino ang nauna, yun ang may preference. Urban land. In urban land, we have a right of preemption and right of redemption. Whenever a piece of urban land which is so small and so situated that a major portion thereof cannot be used for any practical purpose within a reasonable time, having been bought merely for speculation, is about to be resold, the owner of any adjoining land has a right of preemption at a reasonable price. If resale has been perfected, the owner of the adjoining land shall have a right of redemption also at a reasonable price. When 2 or more owners of adjoining lands wish to exercise the right of preemption or redemption, the owner whose intended use of the land in question appears best justified shall be preferred. Yung right of preemption, you exercise that before the sale is actually perfected. So halimbawa, yung katabi mong lupang maliit sa urban land, which you think was bought merely for speculation purposes, nabalitaan mong ibinibenta sa ibang tao, you can exercise your right of preemption, pwede mong harangin yung bilihan dahil ikaw ang may karapatan bilang katabi, bilang adjacent landowner. Pero halimbawa, hindi mo na malayan na ibenta na. Then, what you exercise is right of redemption. Pwede mong bilhin doon sa nakabili dahil ikaw ang may karapatan bilang adjoining landowner. So remember, in rural land, walang right of preemption. Meron lang right of redemption. But for example, the two landowners, the left and the right landowners, would like to exercise the right of preemption or right of redemption, then you go to court because the court will decide who has preference, who has the purpose which appears justified. In which case, that person whose purpose appears more justified will have the right to exercise the right of preemption or right of redemption depende sa decision ng court. Legal redemption period. The legal redemption period is 30 days from notice in writing by prospective seller or sellers. The deed of sale shall not be recorded in the register of property unless accompanied by an affidavit of the seller that he has given written notice thereof to all possible redemptioners. The notice plus copy of deed of sale must be given to the possible redemptioners to inform them of how much to pay. Although the law says that a written notice must be served upon all possible redemptioners, we have jurisprudence stating that the written notice must be accompanied by a copy of the deed of sale in order to inform the possible redemptioners of how much they are going to pay in the event that they decide to exercise their right of redemption. When does period of redemption begin to run? The right of legal preemption or redemption shall be exercised within 30 days from written notice by the buyer. The deed of sale shall not be recorded in the register of property unless accompanied by affidavit that the buyer has given notice to redemptioners. Case doctrine on legal redemption. In the case of Cabales et al. Versus CA, the Supreme Court said that if a prospective redemptioner is informed of the sale of a portion of the property subject of co-ownership, he has to exercise the right of legal redemption within 30 days from notice. Otherwise, he loses the right. If a property subject of co-ownership is sold and is redeemed in its entirety by one of the co-owners, does the redemptioner acquire sole ownership? Why? Answer: no. A co-owner who redeemed the property in its entirety did not make her the owner of all of it. The property remained in a condition of co-ownership as the redemption did not provide for a mode of terminating co-ownership. In the same case, a property was the subject of co-ownership. The co-owners sold their undivided shares in 1978 and informed the others, like Nelson, a minor, of the same in 1993. He signified his intention to redeem the subject property during a barangay conciliation process, but filed an action for legal redemption only in 1995. Can he still exercise the right of redemption? Why? Answer: no, because he did it beyond the 30-day period from the time he learned about the sale. If you find this presentation helpful, please hit the subscribe button to receive notification of future presentations. Thank you.